Please proceed.
Good morning. May it please the court. My name is Richard Volantis, and I represent the state of Florida, the appellant and cross-appellee in this case. I'd like to reserve 11 minutes of my time for response and rebuttal. State's issue on appeal. Defendant was found guilty of 55 counts, and the bottom of the guideline score sheet on those 55 counts was 157 years in prison. At the sentencing hearing, the state asked for life on all the counts, and the defendant asked for the bottom of the guidelines. Instead of doing either or, the trial court decided it was just going to impose a 25-year minimum mandatory sentence on the counts, and the defendant never filed a motion for downward departure. The state, of course, objected and said there was no basis for this departure whatsoever. And again, the fact that the defendant never asked for a downward departure, yet the trial court still entered the sentence as it did. It's the state's position, this case, this court's opinion in Murray is directly on point, which is a situation where the defendant pled no contest and the trial court entered a downward departure. Like the trial court in this case, didn't give any reasons for the departure, nor did it even say it was departing. There was no written order, which is required under the law, and the trial court didn't set forth the facts to support the downward departure. This court reversed the sentence in Murray and sent it back for a guideline sentence, and it's the state's position that that's exactly what should happen here. The defendant's argument in this case that somehow the state waived the court's or imbued the court with the ability to enter an illegal sentence and run afoul of Florida law really doesn't make any sense. And as a matter of fact, when you look at it in context, what the prosecutor was arguing was, Judge, we want life sentences. However, if you don't go life sentences, we want the bottom of the guidelines and 25-year min-mans. And if you go below the guidelines, that's going to be an illegal departure. And again, there was no evidence presented at this hearing which the trial court could have even based a downward departure on. So it's the state's position on that the defendant's sentences in this case must be reversed and remanded for a guideline sentence. Thank you.
Good morning. Ian Selden of the Public Defender's Office on behalf of Dr. Barry Schultz. In response to the state's argument, yes, it was waiver. The state asked for life imprisonment or 25 years. Waiver could be explicit or implicit. It could, in this case, I think it was a hybrid of both. The state said they will be willing to take 25 years as the lowest sentence that they would ask for. The trial court was privy to the initial plea offer of 3 years on 74 counts of trafficking, 3 years imprisonment, and I believe the judge took the state attorney at her word, imposed 25 years, and then the state got upset and objected.
Can you clarify for me what the actual sentence was? Was it?
It was
it was 25 years?
It was 25 years to all trafficking counts that required a 25-year sentence. There were 2 or 3 other counts that were 15 and 3-year trafficking, and in the trial court imposed corresponding sentences as to those minimum mandatory terms, and he made it all aggregate 25-year sentence.
Okay, so when the state argued for sentencing, did they argue life or a 25-year, or did they argue life but with a 25-year?
I believe it was or. That's how I read it. It was or.
But didn't the defense ask for the bottom of the guidelines? Why would the defense ask for more than what the state's asking for?
I don't know, because the defense didn't, well, arguably did not preserve a JOA either. I mean, there's a lot of problems with the defense which are really not germane to the issues at bar, but I have a record, this is what appeared on the record, and this is what I argue. From the record, the state made a statement which can be looked at as a waiver.
Can you tell us where in the transcript that appears?
That would appear on the supplemental transcript. I believe it was page 18, but I will double check. It was on supplemental transcript page 4. And that's my completion of my argument on the state's direct appeal. On Dr. Schultz's cross appeal, the only crime that was committed was the prosecution of Barry Schultz for trafficking in oxycodone. All the evidence elicited by the state showed that he acted in good faith within the course of his professional practice in prescribing opioids of various varieties to the 5 patients. These were 5 patients of a 400-patient practice. Only 5 were receiving high and ultra-high dose of oxycodone. None of the patients, when they first came to Dr. Schultz, were opiate naive, meaning they were on opiate therapy prior to their arrival. 4 of the patients he had treated for 7 to 8 years. And so you're talking about regimens that were increasing over time as they were becoming opioid tolerant. All the patients knew they were opioid tolerant. All the patients had either had surgery or feared surgery and didn't want surgery. All the patients either had injectables or refused to have injectables. There is no evidence that he did anything wrong whatsoever. Whether you view this as a preserved error in failing of the state to negate the affirmative defense, or you look at it as an affirmative proof that no crime was committed, or if you review it as ineffective assistance of counsel on the face of the record for making a boilerplate judgment of acquittal motion, the bottom line is there was no crime committed whatsoever. The state's expert, to the extent that his testimony was admissible, explained what is required of a physician who is engaging in pain management practice. Dr. Schultz did examine his patients. They had verifiable injuries by objective means, by MRIs and X-rays and CAT scans. He discussed their prior surgical procedures with them. He discussed the results of the MRIs. He went so far as to treat one of the patients, RL, for a grand mal seizure. In their closing argument, which is another issue of error, the prosecutor says he was dedicated. Well, a dedicated doctor is faithful to his practice. That's what the state proved. He was a doctor who cared. And maybe he got bamboozled by a couple of his patients. Maybe he should not have been so naive. Maybe he should have been more street smart, but he wasn't, and that's not a requirement of being a doctor. A doctor is supposed to do no harm in treating his patients. He treated them palliatively. That was his background from hospice care. It is not wrong per se. As a matter of fact, all pain management is palliative to the extent that it doesn't cure the condition. It treats the condition, the symptoms of whatever caused you to have this intractable pain. These were chronic pain patients. 2 of the patients wanted to get a lower dose, and he worked with them to lower their doses until he was shut down and arrested. So all the evidence that the state put forth, except that their expert testimony, to the extent that their expert, Dr. Rubenstein, claimed that Dr. Schultz's procedures did not meet the community standard, well, his opinion on that point is not sufficient evidence. It is legally insufficient because it is not competent substantial, because he admitted he never had all the information on the patients. And ironically, to the extent that he was a member, he was a fellow in the American Academy. I have the American Academy of Pain Management Physicians, their expert testimony provisions require a member of their organization to have an informed basis, to make a good faith opinion, to review all pertinent aspects of the case and remain objective and avoid conflicts. Well, he had a conflict. He was Murray, the detective's pain management doctor. Number two, the state and the police built a Chinese wall around him and didn't give him access to the patient interviews. Didn't give access to the depositions and kept them ignorant. They could have had him in the courtroom while these patients testified. They didn't have that done either. They kept them ignorant. And he did a review of the records. The records were either poorly maintained or there was a computer glitch, which Detective Murray acknowledged that there had been a computer glitch when they first went to seize the first set of records on the first search warrant. So here's an expert looking at records that don't say anything. He didn't even have the MRIs. He did not have anything about these patients, which did exist, which were in Dr. Schultz's office. And he's making these grandiose opinions on nothing. The precedent that this court holds in the Schindler elevator case, if an expert doesn't know all the aspects, the opinion is not worth the paper it's transcribed.
Was that argued with the trial court?
No, it wasn't, and it doesn't have to be. Because if you read the line of cases, the MAD case, I believe, the Schindler case, there's no mention, Davila versus Mesa, there's no mention whether or not an objection was made. I mean, an objection could have been made. No, that is insufficient to strike it because it's not.
And so do you have a case you can cite to me that says that everything you just argued is fundamental error?
Fundamental FB, Griffin versus State, that if the state affirmatively proves that no crime is committed, it is fundamental error, because it's an equivalent of denial of due process when the state fails to prove any element of a crime. And that's what we're arguing before you. Or alternatively, that there was judgment of acquittal should have been made and weren't made. Moving on to the second issue, the evidentiary issue. The trial court erred in admitting Hodgson's testimony about that letter. All she recalled about the letter was that there was something wrong with the dispensary and it could not operate. And if she continued to work there, her license as a pharmacy tech was in jeopardy. It doesn't say the reasons why, whether it was a criminal, whether it was a civil, or maybe he didn't pay the fee. We don't know. It's not of record. The state certainly could have gotten that of record. I mean, they have access to the Department of Health and could have got a copy. They didn't. But they're saying because she confronted Dr. Schultz and he said, I'm sorry you had to hear about the status of the dispensary this way. I can't talk to you now. Take the rest of the day off. And when she says, no, I want to talk about it now, he goes, please, leave. I can't talk to you. He never said he wouldn't. He never said, hey, keep this, shh, don't talk about this. I'll fix this. Whatever it was. The state sought to admit this testimony on the effect it had on Hodgson, which is totally irrelevant because the effect that it had on her had no bearing on any material element of the case. What did she do? She went home and quit. That was the effect of him not wanting to discuss it at that moment. But what it really was to admit, the reason why the state admitted, and it comes out in closing argument, was this was a building block on stacking inferences. They were saying, oh, there's something wrong with the pharmacy, the dispensary. Therefore, because there's something wrong with the dispensary's in his office, therefore he was not prescribing in good faith.
Wasn't there a limiting instruction for the jury to consider it only on from the standpoint of the defendant's reaction?
But his reaction is irrelevant. Go ahead, take the day off, I'm sorry I didn't talk to you about it before. I mean, what relevance does that have? Unless you're stacking inferences.
Was there an objection to the instruction?
It was an objection to everything. It was an objection to the whole line of questioning. I mean, the judge, they didn't ask for a limiting instruction, the judge gave the limiting instruction.
Okay, but did the defense object to the instruction as given for any reason?
I don't believe there was a specific objection to the
So
instruction.
is that fundamental error?
I don't think there has to be an objection to the instruction. He objected to the entire testimony. I mean, what else, I mean, how many hoops does a party need to jump through, Your Honor? I mean, there was no basis for this testimony to get in, except for the state to argue, see, he didn't talk to Hodson's, and that shows you he did not prescribe in good faith. See, he had a dispensary. The dispensary was there for a year. Even though he didn't have this, patients had to use it. Some did, some didn't. You have patients using it and then using pharmacies. There was no requirement. This was not like these line of cases with doctors who were found to prescribe in bad faith or not in the course of professional practice, where they say, go to this pharmacy in the county, 2 counties over. They won't give you a problem with your prescription. That was not the case here. They could use the pharmacy or not use the dispensary. I'm sorry, this dispensary. The dispensary had nothing to do with trafficking because once he wrote the script and handed it to the patient or gave it to Hodson's to be filled, the alleged crime would have been completed. That's what King holds. So whatever legal status issues the dispensary had did not have anything to do with his prescribing practices whatsoever. Thirdly, on the closing argument, there are some parts that were preserved, and there are other parts that were not preserved. And this court's review on the fundamental error that it deprived the defendant of his, went very down to the very essence of the case to deprive the defendant of due process. The state argued that while he is a good doctor, while he is devoted to his patients, he did not prescribe in good faith because he wasn't board certified to practice pain management medicine. That's not the law in Florida. It is the antithesis of the law in Florida. The law in Florida states that any physician can limit their practice to any discipline within medicine, but they can only hold themselves out as board-certified physicians if indeed they are board-certified physicians. You graduate medical school, you want to be a psychiatrist, good for you. The state of Florida does not put any restrictions on it. If you want to be a dermatologist, well, if you're board-certified, you have to have certification every 3 years, but that's the only thing. It's a caveat emptor. You go to see a doctor, he doesn't do a good job, well, buyer beware. But that's the law in the state of Florida. To argue that he did not prescribe in good faith because he wasn't board certified took everything out of his defense. He wasn't board certified. He didn't have to be. And that's why the argument is fundamentally erroneous. And if I could have a few minutes, I know I went over, but if I could have a few minutes. Thank you.
Well, first of all, I would encourage the court to look at page 4 of the sentencing transcript. There's absolutely no waiver whatsoever by the state of the trial court imposing a legal sentence pursuant to the guidelines. As a matter of fact, on page 5, the direct quote from the state is, "So, is the state's position. The state's position also is that anything less than the 1890-75, which calculates to 175 years, anything less than that would be a departure from the guidelines, and there would be no appropriate reason for such departure. So not only is that the state's alternate, you've got life or you've got the bottom of the guidelines. As soon as the trial court entered this, did he say, oh, okay, I waived it? No, what happened is the prosecutor immediately objected. So there was no waiver whatsoever despite the representations to the contrary.
Did the state ask for life or 25 years?
No, not at all, Your Honor. The 25 years was life or sentencing guidelines with 25-year min-mans. That's what was requested. And I looked through the brief. I haven't come across a case that says, well, if you're a dedicated physician and then you decide to deal drugs by prescription, then you can't be convicted of trafficking. That case doesn't exist, but that's what the defendant's argument is today. And his argument to the fact that do no harm. Well, this defendant did tons of harm. Well, how do we know that? Let's see. KH testified, I got so many prescriptions, I became addicted. PG testified, I became addicted, had to go to detox because of all these prescription medications that the defendant was prescribing me. MD testified, yes, I got addicted to the pain pills that this defendant prescribed me. That doesn't sound like doing no harm to me. And this whole argument that the dispensary is not at issue, I think the dispensary is a huge issue because this is the profit motive. As the testimony was, particularly from KH and Ms. Hodson, the defendant claimed to Ms. Hodson, who ran the tech, was the tech at the dispensary, he ran a general practice of interning and geriatrics. After she got there, she noticed a change in the clientele, and what was happening is the guy's prescribing copious amounts. We're talking 1,000 to 2,000 pills of oxycodone, 30 milligrams per month for patients. And that is well beyond, as Dr. Rubenstein said, not only are these not medically justified, these are grossly excessive prescriptions. And that clearly shows that they were not made in good faith. And the fact
But
that
just because there were thousands of pills, I mean, it depends on how many patients there are, doesn't it?
Oh no, thousands of pills for one patient, Your Honor. As a matter of fact, this whole, oh, well, the dispensary doesn't matter. Well, KH testified, particularly to larger prescriptions he would get from this defendant. Defendant wouldn't let him take them out of the office. Well, what does that mean? No doctor writes a prescription and says, here's your prescription, but you can't take it out. And he did take one of them out. He took the one for the almost 1,600 pills out, and that's what brought this whole prosecution on, because the pharmacist that got it said, whoa, this is well above and beyond anything I've ever seen. And he turned it over to the police, and that's what started. And again, when the police came to arrest him, and he said, oh, I think that this one guy, KH, he might have been, diverting his pills. And the police asked him, well, why didn't you fire him as a client earlier? Oh, I was making too much money off of him. Well, if that's not indicating something being prescribed not in good faith, I don't know what would be. And the guy also testified that when he was being arrested, I didn't do anything wrong, I didn't understand, well, maybe I prescribed a little too much. Again, that's showing what the business model was and what was going on in this case. And Dr. Rubenstein, not only did he say, a lot of these, for example, KH comes in one time and actually told the doctor, you know what, I'm feeling a little bit better, my pain's less. Doctor's response, of course, under the do no harm is, I'm going to give you some more OxyContin. What sense does that make? How is that not doing harm to someone who gets addicted to these substances, and when he says he's actually feeling less pain, you give him more? I mean, I don't see how that could be anything but prescribing in bad faith and outside of the scope of the practice. Regarding the second issue, my only response would be this is something, and first of all, this was never introduced to do anything with Mrs. Hodson. This was direct, and the court, as Judge Klingon-Smith pointed out, there was a curative instruction that specifically said, this is only, you can't consider the probative value of this at all. Only thing you can consider this for is the reaction of the defendant. And the defendant's reaction was, oh, I'm sorry you had to find out that way. Basically showing what his business practice was regarding the dispensary. And as far as the third issue, apparently the defendant's argument is, well, we don't have to object to anything that happens in or in closing argument anymore. We can just raise it and say it's fundamental error. I would point this
That
court.
was a misstatement of the law, the argument that was made, right? I mean,
No.
the fact that he had to be board certified, and if he wasn't board certified, then that shows evidence of bad faith.
Well, that's not the argument that was made, Your Honor. As a matter of fact, the quote, and I would quote page 2563, which is the actual objection that was made. Quote, the state of Florida requires, the prosecutors argued that when a defendant steps out of his role of an internist or geriatric care, the state of Florida requires him to be able to do that, to have training and education. Okay? That's where it is. That's what he said. Objection, improper argument, misleading. How is it an improper argument? Don't know. How is it misleading? Don't know. But what we do know is the trial court on page 2558 of the record specifically said, whatever these attorneys are telling you about the law, I'm the one telling you the law. So this whole thing that, oh, because this one isolated partial sentence said by the prosecutor during closing argument somehow becomes fundamental error entitling the defendant to do trial is beyond the pale. I would point the court to the Dix case from the first DCA, which is 75 Southern 3rd, 857, which the defendant does not address in his reply brief, where the prosecutor in that case repeatedly used the wrong definition of dwelling, not fundamental error. And the cases that the defendant cites to support this argument, I'll say Fenster was a situation where the prosecutor actually argued facts not in evidence, not what we have here. And in fact, that case, the defendant objected properly and repeatedly. Again, not done here. That's why it was reversible error. The Pisalo case, the court gave a bad jury instruction. And the defendant actually used that bad jury instruction to say, hey, the jury instruction says there has to be an injury here. We have no evidence of injury. I win. Again, using a bad jury instruction, bad argument, that's reversible error. And finally, the Pollock case, again, was a bad jury instruction, and it said the defendant had to be in imminent danger of death or great bodily injury from sexual battery that was alleged to have occurred. Well, that's not the law, and that was improper. And the defendant, or the prosecutor, mentioned it 5 times during closing argument. Again, we don't have any of that here. And the state would request, particularly on the illegal sentence that was imposed, the court reverse and send it back for the imposition of a guideline sentence like it did in Murray, and affirm on all counts, because the defendant definitely didn't preserve his judgment of acquittal argument. There is no ineffective assistance of counsel on direct appeal. And we have no idea what the strategic thoughts were going through the mind of trial counsel. It's entirely possible trial counsel thought, you know what, maybe I'm not going to make this argument because it doesn't make sense. We've got a guy saying he wrote me prescriptions that he would not allow me to take out of this office to fill at a legitimate pharmacy. That is a hallmark of bad faith and practicing outside of the scope of professionalism. Thank you, Your Honors.
Thanks. I'm going to take a couple minutes to rebut.
Cage's testimony was, if you read the whole thing, it was a stream of consciousness with many internal conflicts. To the extent that he wasn't able to take the prescription out. But so what did he do? Steal it? Again, that does not vitiate everything else he testified to. That he took all his pills, he needed the pills, and the doctor helped him.
Can I ask a question? Because it looks like the record's showing that in some 30-day periods, 1,500 pills, and some other 30-day periods, 2,200 pills.
Sure.
Do you even need an expert to come in and say that's grossly excessive? That's like 50 to 70 pills a day.
Yeah, it's about 72 pills a day.
So
Actually,
you would have to set your alarm and 24 hours a day, every hour, on the hour, take 3 pills.
well, actually, it's about 9 pills a time, 4 times a day. But it was not excessive because both experts.
I'm sorry, my wife's a nurse practitioner.
Well, you know, I don't think
and that's,
well,
I mean, that's a crazy amount of pills.
it is a crazy amount of pills. However, according to Rubenstein, the state's expert, 1 to 10% of persons who are pain management patients who with chronic pain who have taken opiates over a period of time build up high tolerances and require high and ultra-high doses of opioids. They agreed to that. Percentage-wise, the 5 patients were less than 2% of Dr. Schultz's practice. So they agreed. It was no dispute that certain patients need those. And out of 400, 5 out of 400 is not out of the realm of acceptability. As far as them being addicted, that was colloquial addiction because none of the patients says, I was getting in trouble, I was late for my job, all I did, I was stealing. There was no aberrant behavior which is required to fit the agreed upon definition of addiction in the record. Both experts agreed that the addiction is using something to the extent that it is adversely affecting your ability to exist and perform in society. And there was no evidence. Evidence was to the contrary. It actually helped them function. A woman with back injuries and gynecological problems exacerbating her pain, who had 4 young children, a guy who was a salesman who had children he wanted to play with and get out of bed, a woman who cleaned houses, a man who did construction work, another man who was found to be disabled just on the basis of his pain. We're not talking about I hurt my knee and all of a sudden for an acute pain they're getting all sorts of prescriptions. This is not the case. As far as
Let me ask you about the final argument, the closing argument.
yeah,
You brought it up. I asked Mr. Fluntus this question. Did the state make the argument that the defendant had to be board certified in pain management?
if you look at the argument, basically from page 54 through page 60, if you look,
Did he say the words board certified? in
yes,
his
there's
closing?
he wasn't board certified. Those
Okay,
words
so he wasn't board
are
certified, but
used.
did he make the argument that you had to be board certified in order to have good faith?
Directly, it was very convoluted, it was roundabout, but if you read page 2553 through 2560, the argument is there.
We talked
That
about
was-
training and education, but
Training, education, board certification. The training, that was the only objection. The board certification argument came a few pages later. But that's all that's all the state had. And as far as the judge's instructions, there was no instruction on on the status of being a physician and whether you can or cannot prescribe drugs. It was just the fact that he was a physician, and the fact because he was a physician, he could have this defense. But there is no issue going back to good faith. Good faith is defined under the third DCA case, the airport fuel case, Cliff.
Wrap it up if you would. Which is
Anyway, the state affirmatively proved that Dr. Schultz prescribed opioids in good faith and in the course of his professional practice. The evidentiary issue, the instruction was erroneous because they had to assume that they could not ignore the truth, because in order to understand the reaction, you had to assume it was true that the dispensary lost its license. And it was fundamental error in closing argument. It took away Dr. Schultz's defense. Reverse and affirm the sentence. Thank you.
Thank you, gentlemen. Let's do this. We have one more on